Hello everyone, and thank you for joining this Use Laboris webinar. My name is Annie and I will be facilitating the session for you today. So today's session will be given by a set of panelists, all from different member firms of Use Laboris. That's all from me. I will now turn over to Alex to start today's session. Go ahead, Alex.
Thanks very much, Annie, and welcome to everyone. A few people are still coming in, but I think I know everyone is very busy and probably wants to get back to their work, so I will crack on. Welcome to the first speed dating session in terms of data that we're going to run this year. Some of you might have attended our first session last year in relation to subject access requests, and it was quite popular in that over the course of the next 30, 35, 40 minutes, you'll hear from various lawyers around the world at a high level in terms of the key elements that relate to workplace monitoring in their jurisdiction. You're not going to learn everything about monitoring. The whole idea is to get a snapshot from various countries. And this session today is about monitoring, but we're going to run 3 more speed dating sessions over the next year, probably quarterly. The next one is on artificial intelligence in the workplace, a rising topic that we advise on every week now at Lewis Silkin. And we're going to have a session just running through fine profiles in Europe and the UK from GDPR and UK GDPR, just to work out where the real risk pinch points are in terms of enforcement action and fines. I'll probably also talk about the rise in class actions in the UK, and indeed there is a big class action in relation to the workplace currently going on. And then the final session is going to be on a very hot topic that a lot of us get asked about, criminal records checks, and what is the intersection there between the workplace and data rules on checking criminal records checks. And the whole point of these speed dating sessions is so you don't just hear one voice or one jurisdiction. The position in relation to monitoring, as we'll see today, is different in Germany as it is in Singapore, as it is in Ireland. But we hope with all these sessions through the year, you'll get a flavour for all the differences. We'll probably also have an ad hoc session this year on the UK's adequacy decision and maybe the new standard contractual clauses, just so that everyone is up to date on how data transfers happen. So back to today's session, I will just briefly introduce the speakers. There's obviously myself, Alex. I'm the co-head of the data and privacy team at Lewis Silkin. We then have Jessica Jacobi from Klimt in Germany, who is a workplace expert and a data and workplace expert. We then have Linda Hines from Lewis Silkin Ireland, who's similar expert. We then were going to have Basile Moore from Capstan in France, but I'm sorry to say that by dint of emergency circumstances, he's been called away. So I will attempt to cover his sections on French law, and I will be extemporizing. So forgive me, it won't be quite as good as Basile, but I'll try my best. What I wanted to do for this session was then not just focus on Europe and the UK. So we then very lucky to have Lionel Tan from Raja & Tan, who is a data and privacy expert from Singapore, who I've worked with a lot. We then have Nick O'Connell from Al Tamimi, who is based in Saudi, but this is rather grand, but can talk about all Mideast regions, especially obviously UAE as well. And then last but never least, we have David Swain from LS Hong Kong, who's going to give us the Hong Kong perspective. And as Annie has just said there, if you can ask any questions in the Q&A, I'll try to follow them, and I might ask them throughout, or I might wait to the end to cover them. So I thought we'd just start with a poll question, which Annie is going to put up now, rather simple. But I wonder if you might just spend 15 seconds just answering those 3 questions. Do you engage in general monitoring of your workers? Well, I can even do it. Do you use sophisticated automatic data loss prevention systems? And have you seen an increase in monitoring that you engage in during COVID-19? So I think, Annie, we just wait 15 seconds for those results to come in.
Yeah.
And just while we wait for those polling results to come in, the reason we wanted to do monitoring was it is a hot topic all the way through the year, and over the last 5-6 years, there have been many pan-European and pan-international projects I've been involved in relation to monitoring. But we have seen an increase in questions from clients in relation to monitoring over the COVID pandemic, because people are looking at interesting new ways to monitor their employees, new techs come in, Let me have a look at this. So do you engage in general monitoring of your workplace? Okay, 44%, so 50-50, which I'm quite surprised about. I always assume that everyone monitors their workers, but that's probably because I'm British. Do you use sophisticated automatic data loss prevention systems? Majority not. Again, I'm quite surprised around that, probably because I work for so many financial services clients who obviously do engage in the use of DLP systems. And have you seen an increase? So 50-50. Okay, interesting. And there will be one more poll question later just to see how we're doing. But just before I go on to the kind of monitoring that we're talking about, I've just got a few quotes from the United Kingdom ICO and then the European Data Protection Board, specifically where they addressed around 6-7 months ago, towards the start of the pandemic, that COVID didn't mean that there was a carte blanche for monitoring. Indeed, the ICO said that it's about being proportionate, and if something feels excessive, then it probably is. Now, they applied that to all types of monitoring that was happening, monitoring relating to COVID tests and so on, but they were specifically talking about, in one section, discussion of monitoring remote working. And the head of the EDPB, Andrea Jelinek, said, look, data protection rules don't hinder measures taken in the fight against coronavirus. However, I'd like to underline that in these exceptional times, data controller must ensure protection of the personal data of data subjects. So you have to still think about data protection, even though we're in the COVID pandemic. And the position we're going to talk about today is different in the UK as it's different to Germany and Ireland, and indeed is very different in some of the APAC regions and Middle East that we're going to talk about. But just so we understand the language, the kind of monitoring that we're going to talk about today range from specific and ad hoc monitoring. So this is probably the most common one that we deal with, where there's been evidence of a data theft, evidence of someone potentially starting to prepare to compete. You know, they're going to steal a client list. And we often get a call from a client saying, look, we've got this evidence, we'd like to monitor this person's emails, either going forward or retrospectively, we want to look at the last 3-4 weeks of emails. We then advise a lot on general systems monitoring. So monitoring of internet usage, messenger usage, and so on. There's then a lot of tech involved that we advise on, and I know a lot of people on the call do as well, from high-tech stuff to automatic data loss prevention systems, including some word recognition and linguistics. I have advised on a number of systems which actually recognize specific words that people are using in their emails and highlight whether they're a risk or not. To obviously low-tech stuff. Monitoring in the workplace also includes CCTV. And in fact, a lot of the cases, you'd be surprised, a lot of cases around theft from the workplace and the question of how much you can use CCTV to actually monitor your employees. There's then lots of different purposes that people use monitoring for, from the ad hoc purposes to the DLP purposes to this new one that we've seen emerge over the last year. It's always been knocking around, but productivity purposes. How do I know that Linda in Ireland, when she's working from home, is actually at her workstation and isn't on holiday or whatever? So we have had a lot of discussions with clients about how far can you push that productivity monitoring. And then they all have very different risks, as you can imagine. Vanilla monitoring versus enormously wide-ranging, disproportionate monitoring. It doesn't take a rocket scientist to understand that there's different risks there. And then finally, one of the most important non-legal concepts, but we use it all the time in the monitoring world. And indeed, the ICO mentioned it earlier, if something feels excessive, it probably is. And we tend to say, certainly Linda and I use this language, if something feels creepy, okay, in your gut feel, it's not something you'd necessarily want to happen to you. And I always use fatuous examples, but we used to talk about it all the time with clients. Private investigators, let's follow employees home. Let's put drones over them to see whether they're actually going for other interviews and so on. That is quite creepy. It's unlikely to therefore potentially be proportionate. So that's the scene. I've set the scene there. We're going to now go through sort of 5 sections where I'm going to ask for comment from my wonderful speakers. First, we're going to talk about why is this important, and we're going to talk about some recent case law in Europe, including one very interesting case in Germany that Jessica's going to talk about. We're then going to pivot from Europe and the UK to the East, the Middle East, just to understand some cultural and legal differences, so we can get that flavour of quite how different it is around the world. I'm then going to talk about the basic legal position, and we'll then touch base with a few of the countries there. Then some of the countries are going to raise what are the big red flags in each jurisdiction. And I'm going to have to cover France there, so forgive me, but there we go. And then we'll end with some horizon scanning from each person, including me. Where are we going to go in the next 2, 3, 4 years? What kind of new tech are we going to see? It probably leads nicely into the fact that we're doing an AI session later this year, because we are seeing a lot of AI and monitoring intersect. So first section, why is it important? I'll set the scene. You need to get this right because you need your workers to trust what you're doing. Lack of trust and monitoring are synonymous. Creepy monitoring and lack of trust are synonymous. That then leads into employee relations issues. I know Jessica's going to touch on collective consultation in her section and negotiating, sorry, wrong word, but you know what I mean, talking to works councils. And if you're losing that trust, that makes that difficult, and you're using your capital to try and push through some creepy monitoring that might bite you later when you're in pay negotiations. We then obviously have all the usual risks, GDPR and UK GDPR fine levels. They're not insignificant. And had we had this a year ago, I probably would have said workplace monitoring is low down the list of fines, but Jessica's going to give us some comment in a moment. In fact, I'm coming to you, Jessica, in about 15 seconds, about a big case in Germany where the fine profile was material in relation to workplace monitoring. In the UK, we're also seeing the rise of class actions. And I do think there's going to be a class action. There is already a class action from employees at present, but I think there'll be more and more over the next 2, 3, 4 years. And they might come down to, over the course of 7 years, X company systematically abused my privacy by monitoring all my personal emails. I'm going to engage 3,000 employees to sue you for £1,000 each. Now, it's not much for only one employee, but 3,000 employees suing you for £1,000 each is a significant amount of money. And then, of course, PR. We'll see from the one that Jessica talks about, and indeed the one I'm going to go on to now, that the PR can be terrible. So, equally, however, it's important to monitor. Data loss prevention, productivity, and system usage are important things. So, as ever with data, there's that balance between data and workers' rights and the law. So we're just going to run through a few interesting cases. I'll do 1 minute on Barclays, and then we'll come to Jessica for H&M. But Barclays, this is still ongoing, and I'm in no way criticising Barclays here. I'm just reporting the facts as I know them. But it was mid-summer, I think, last year that it was announced that the ICO was investigating Barclays for using computer monitoring software to track its employees. And this is a nice one to start with. It's ongoing. There could be a significant fine, but it's very relevant in terms of the use of tech. Barclays are using Sapience. In no way, again, am I criticizing that product. Just it is referenced. They're using Sapience, which monitors productivity rate, computer usage, keystroke checking and all that kind of stuff. And then they're also using Occupy, but Occup, capital E-Y-E, which tracks time spent at desks. So if we go back to that creepy element, I'm not sure I'd call a product Occupy. I would call it something vanilla like Gentle Monitoring product. But you can see there's that element of using those. Even Sapience has that ring to it of it might be a little bit more intrusive. And I do recognise, talking to clients, that a lot of this monitoring tech has actually bled out of intelligence agencies. I remember vividly having a meeting with someone who was claimed to be anyway ex-CIA, who had developed some linguistic monitoring. So you can see there's very different worlds from intelligence services to the workplace. So that is one to watch. But one that we don't have to watch, one that we already know the result of, is H&M in Germany. And I'm going to pass over to Jessica now for a minute.
Thank you, Alex. Yeah, you just said if it feels creepy, it probably is. And this is certainly a case where you could have had the feeling that the employer was doing something creepy. They had a system installed in their branch in Nuremberg, which was a small branch with roughly 70 employees, no works council. I will come to that later. And they had a system of so-called welcome back talks. So everybody who had been on vacation or who had a sick break was asked for a confidential meeting. And how are you doing? How's your family? How's your health? Are you any better? And the employer was actually taking note of the results of those welcome back talks. And the results were available to roughly 50 managers throughout the branch and the company. And only by mistake was this becoming known to a wider scope of participants. The Hamburg Data Protection Authority was in charge of this matter as the legal entity has its headquarters in Hamburg. They investigated, they put a freeze on the data, they investigated, and they handed out a fine of 35 million euros, which is of course a record for workplace data privacy breaches in Germany. This fine was handed out on 1st of October, and HM stated they would be considering their options, and on 22nd of October, they have stated, which is quite remarkable, that they will accept the fine, although they consider it to be fairly high in proportion to the small scope of what happened. To give you a counterexample, there were two more large cases with 2-figure million fines, and both have filed a complaint against the fine and have been able to negotiate down the fine to a significantly lower amount. But as you just said, Alex, it is probably also the PR effect. If they did something really creepy, and if they had gone against that in litigating against the fine, this would probably have produced more negative PR than they would have saved, on the other hand, by going into litigation against the fine. Thank you, Alex.
Thanks, Jessica. Yeah, it's very interesting. I mean, from my perspective, it's an enormous fine. Bearing in mind the British Airways fine, in the end, turned out to be only 20 million, and that affected, 500,000 UK consumers. The Marriott fine, affecting over 20 million European and UK data subjects, was only 20 million euros. So I think Hamburg there maybe wanted to make an example of H&M. I've now got on my notes that Basil is going to speak, but in fact, I'm going to speak for literally 25 seconds. And this is really just something for the listeners to take note of. If you want to read a case that gives you the archetypal position in Europe and indeed the UK about monitoring, just read the Romanian case of Barbulescu. Barbulescu involved a Romanian company monitoring someone's Yahoo personal messenger that actually he'd been told to set up for company purposes, but he was also messaging his family. And it actually is very interesting because it went to the Grand Chamber of the European Court of Human Rights, which I'm going to talk about the intersection of different laws in a moment. But do read that case, because the Grand Court of the Chamber of the European Court of Human Rights actually criticised the Romanian company and just said that no matter what you do in terms of telling people what monitoring you're going to do, you can never totally extinguish the right to privacy. And so they absolutely emphasise there some of the core messages that will come out today. Proportionality is absolutely key, and it comes back to that creepy test. But I don't have much more to say about that, as I haven't read the case for about 5 years. But just do look up that case. In fact, we did do a big article on it, which I might attach when Annie sends out the follow-up to this. We're just going to move on to Linda for 1 minute on CCTV in Ireland, just to get a perspective on something that's very low-tech. Although I do appreciate, Linda, that CCTV is becoming more high-tech in terms of facial recognition. But I think over to you, Linda, for an Irish perspective on CCTV.
Well, it's quite interesting in the poll that we had a 50-50 of people saying they don't monitor their employees, but if you have any CCTV in your workplace, of course you are monitoring your employees. So we do see monitoring as an emerging area for Irish employers, particularly in the multinational space. So if companies are doing things in other countries, they want to do it in Ireland as well. So we are seeing a trend towards diversity monitoring, and certainly, as you were saying, Alex, from the COVID perspective, more monitoring of remote workers, particularly where there might be tax implications if they say they're working in one country, but actually they're working in another. So I know that's a big area of concern for a lot of our clients. In Ireland, as well as the data protection rights, you also have a constitutional right to privacy. So it's kind of adding another reason to be less creepy. Mainly the guidance we have around employee monitoring and the case law and the case studies have focused a lot on CCTV, particularly where CCTV footage is going to be used for disciplinary purposes. And again, it comes back to all the basic principles. So our regulator is very clear that employers have to be really transparent about that at the outset in their privacy notice. If you're going to use CCTV footage for disciplinary purposes, that has to be really, really clear to employees. So we've had a lot of Labour Court rulings around that and whether it's fair that certain evidence was used. We do have quite a lot of guidance in Ireland around the use of CCTV. So our regulator has a really good detailed note on how you should use CCTV, and it goes into quite specific detail about the type of policy that you should put in place. So if you are an employer who uses CCTV as part of employee monitoring, we would recommend you look at that note in Ireland. And it's actually quite helpful because a lot of the guidance would apply to other forms of employee monitoring that's likely to emerge in Ireland. So really watch that space here.
Thanks very much, Linda. And actually, the UK has a similar note. I dare to say that possibly the Irish DPC looked at, or there was cross collaboration on.
I would expect so, yes.
So we're just going to move on to the second section, which I've titled in my notes East versus West via the middle, which is absurd, but that's just who I am. We're just going to move on to Lionel, Nick, and David. And Lionel, I'm coming to you first in a minute. But we've already heard intimations of different cultural approaches to monitoring. You know, Germany is different to the UK, is different to Ireland. And I would say it's not unfair to say that UK and Ireland have taken more inspiration from the US. You know, Ireland especially has more multinationals. It has to play the game in some ways in that it wants people to invest there. And, you know, a US company has its own ways. You know, we've seen this, by the way, with drug testing with a lot of our clients in the UK, who drug testing in the US is commonplace, but drug testing in UK and Europe is far less common. So, but as you move more into continental Europe, there is just a feeling, and indeed Basil and Jessica will hint at this as they go through. Sorry, Basil isn't here, but Jessica will hint at this. There's just slight more distrust of monitoring, and it may be a cultural thing, it may be a historical thing. And equally though, we shouldn't just think of Europe and the UK. It's very different in other parts of the world. And so I'd just like to invite Lionel to make a quick comment on Singaporean approach.
Yes. Thank you, Alex. So in Singapore, I think we do take a slightly different approach. Of course, just on the text of it, we don't actually have a right to privacy enshrined in any of our constitution or laws, but we do have our Personal Data Protection Act, which says that you can do monitoring of your employees, but it will be an exception under managing and terminating of employment relationships. And our Personal Data Protection Act has recently been amended to put in this new exception of legitimate interest. You know, you could say you need to put in some monitoring software for your employees to, in order to ensure there's no fraud, ensure there's some increased productivity, for example. So again, in Singapore, we do accept that. We accept the same point as you have said, Alex, on proportionality, on reasonableness. We use the word reasonableness. Anything you want to do any surveillance of employees, it must be for a reasonable purpose. But coming back to this issue of trust, I mean, I just want to emphasize one case in Singapore. It's not really about employee monitoring, but I think there's some analogy. So in Singapore, we have our government putting in place a Trace Together app, an application, a mobile app in which everyone goes around different places. They have to fill up their information so that the government can trace where everyone's going in terms of COVID for COVID purposes, right? So the controversy occurred when this app was introduced, and to encourage everyone to download it and use it. They said there was a reassurance that it's only going to be used for COVID tracing purposes, and that was a reassurance that was made public. But lo and behold, within about 4 or 5 months thereafter, the government then admitted that actually the police could get hold of that information for criminal investigation purposes. And so there was a bit of a hoo-ha in the sense that people were told, hey, look, you were told that it's only going to be used for that particular purpose. Now we're being told that it's going to can be accessed by the police for investigation purposes. But unfortunately, that's the situation it is. People have to accept it, but there has been some backlash because there's been some decrease of trust in the sense that was what was initially promised. So that's the situation in Singapore.
That's very interesting, and there's a super important reason, in terms of that's a COVID tracing app, and I appreciate that the other purposes perhaps aren't linked to it, but you could perhaps see that if that furore bleeds into the workplace for lesser reasons for monitoring, it would be interesting to watch that space, I think. I'm just going to move over to Nick now, just to give us a general feel for the position in Saudi and UAE in terms of what kind of laws and expectation from employees.
Sure. So I think the starting point is that it's important to understand that privacy is important in the region, like culturally it's important, but at the same time, the modern sort of data protection laws haven't yet been widely implemented. But there's very much a trend towards moving towards a modern approach to data protection. Now, what I mean by that is that there's a lot of countries in the region, and UAE in particular, for example, that doesn't have a modern data protection regime. It does, however, have a couple of key free zones, financial services free zones that do actually have GDPR consistent data protection regime. So if you have employees based in those jurisdictions, the position for monitoring would be quite different to an employee onshore, what we say onshore UAE. Saudi Arabia has recently introduced something called interim regulations on data protection. So they are also moving towards trying to introduce a more modern approach to data protection. Now, in the absence of a modern approach to data protection, what do we have? And the answer is we've got fairly blunt tools. So, for example, the penal code in the UAE talks about essentially disclosure of secrets without authorization. It's a criminal offence. Similarly, filming people without their permission, etc., is a criminal offence. Now, in a very practical context, does that mean that you would be, normal sort of corporate processing and monitoring type activity that would be in the realms of what people would not consider creepy? Would that be a problem in these countries? I would say probably not. But at the same time, the one case that I can think of where these criminal provisions kicked in did involve CCTV in the UAE. So certainly you can't say that there would be no risk that these blunt tools would be used in respect of monitoring type activity in the workplace. But at the same time, it's not a typical scenario. I don't know if that's my time or not.
No, that's right. Well, that is your time, perfect time, but also very interesting. And in fact, I was on a seminar last week. I was only talking about data, but with your colleague, Sami. And he was talking about the different approach to sort of mandatory vaccines and so on within UAE and around Mideast. And it is just one of the purposes today of this seminar, and indeed someone's asked a question about, are there any other countries we should be aware of? Have I chosen these countries specifically because of monitoring? No, the point is just to show that there are different countries around the world that have different views, and you do, even in Europe, we're different to Ireland and Ireland is different to Germany. There are some more similarities in Europe, but you've just got to recognise that a one-size-fits-all approach is quite tricky. And obviously, Nick there is covering UAE and Saudi, and that's two different regimes in and of itself. And UAE, of course, Nick, as you've mentioned, has the free zones and then has the non-free zones. So within UAE, you've got different regimes as well. And I'll just come on, David, just to you for a couple of minutes, just on a Hong Kong general perspective. What can you tell us about Hong Kong?
Yes, hi, thanks, Alex. Hi, everyone. I think that it's interesting to have heard some of these discussions, but I think generally speaking, employee monitoring is quite generally acceptable in Hong Kong. Again, you have to follow the law in terms of the Personal Data Privacy Ordinance, PDPO in Hong Kong, which includes having to obviously notify your employees of the purpose of the collection of data, whether it's obligatory to provide that, the classes of persons who you might transfer to, requesting access to correction of data, etc., those sort of things. But yes, I say, and perhaps the data that might be sort of unusually collected in Hong Kong, it's not as usual to collect diversity data as one might expect in other jurisdictions in Europe and US. But again, ultimately, provided that these sort of provisions have been met, as long as the data is adequate and not excessive in relation to that person, I think this goes towards what everyone has been saying about that it can't be creepy, and as I say, so there is that written into the law itself. So it can't be, as I say, excessive beyond the purpose that you've asked to collect it for. I think it's important to notice that if you don't very explicitly tell people what the purpose is, then you cannot use it for outside that purpose without the express consent of the employee. So if you are going to do it, you have to be very specific from the outset. That's what's important.
Thanks, David. That actually leads on to the next section that I'm just going to do 1 minute on, which is the law. Before I do that, though, a few people have mentioned diversity monitoring. It is obviously a type of monitoring, slightly different in that it's not so active. It's not about checking whether someone's doing X, Y, and Z. It's obviously looking at the makeup of your workforce and has become more prevalent over the last year, bearing in mind issues around Black Lives Matter and so on. We're actually collating on behalf of Youth Labour for around 30 paper. Well, it won't be that short if it's 30 countries, but it's as short as we can make it, a paper on diversity monitoring and what you can expect. Because again, we could have done this today on just diversity monitoring, because the difference between the UK and Ireland and Germany and Hong Kong and so on is very, very broad. And again, that one size fits all approach, which may or may not be being driven from the US, doesn't always work and can put you in a risky position. So in terms of the law, you know, the very interesting point around monitoring, certainly in a workplace context, but also generally, is it's a very complex legal position, certainly from a UK and European perspective, but equally, I think, from the other jurisdictions, in that you have this intersection of sometimes constitutional law. You know, maybe the German constitution has a right to privacy. Certainly the EU Charter of Fundamental Rights has a right to privacy. You then have that intersecting, not to be tautologist, with privacy and with human rights law. So in the UK, we obviously have the Human Rights Act, but also the European Convention on Human Rights. So the right to privacy within that. In the UK, we also have the intersection with things like the Investigatory Powers Act, you know, phone hacking scandal, which some of you may remember, and even the Computer Misuse Act 1990. So it's a lot of intersections there of different laws. And at the same time, you have to overlay on top of that data laws, GDPR, UK GDPR, a lawful basis. What if there's special data you're processing? You know, David's mentioned from a Hong Kong perspective, notice. You know, everyone sort of said that. You've got to tell people what you're doing. Everyone has mentioned proportionality. And obviously minimization, as those of you who have seen me speak before say, I could really just have a session where I just say minimization 100 times, you'd probably get the same value out of it. But it's very, very complex. And then of course you add on to that employment law. You know, you've got things like constructive dismissal. And if you're being too creepy, someone's going to resign and claim constructive dismissal. You might have discrimination law. So Linda and I have at times worked on various projects in relation to facial recognition, which is the type of monitoring that might be deployed in CCTV. One of the massive issues with facial recognition is, of course, discrimination bias. And academic paper after academic paper is written on it. But you can see there that if someone is suffering a detriment because of a discrimination bias in a CCTV algorithm, you might then have an employment claim in relation to discrimination. And equally, there's the final point, which is, of course, works councils that Jessica's going to talk about in a second. But I'm first going to come to Linda, because one of the things that I always recommend with any monitoring, be it general or ad hoc or specific, or if you really want to do something creepy, how can we mitigate risk, is undertake a DPIA, Data Protection Impact Assessment. And I'm going to come to Lionel after Linda, who's going to talk about the rise of DPIAs in Singapore. But Linda, if you could just first take us through for a minute or so on the Irish focus on DPIAs and what a DPIA is and so on.
Sure, Alex, thanks. So I suppose, as we all know, under the GDPR, DPIA is necessary where processing is likely to result in a high risk to the rights of the data subject. So that might not always be the case with monitoring, but certainly from an Irish regulator perspective, they would expect a DPIA. I think it's also important to bear in mind, if you're going to have to go out and tell your employees that you're going to start this kind of monitoring, if you've done all the work that's in a DPIA, that's going to make that information easier to disseminate to your employees. So as a matter of good practice, you should be doing one, even if you've determined it isn't mandatory. And certainly from an Irish perspective, the regulator would expect to see one, or at least expect to see that you've considered the same type of information that would be in a DPIA. So just a very high level, I mean, I think most people on the call, if you're involved in privacy at all, you'll know what a DPIA is. But just to summarize, like the first step would be to actually identify what the monitoring is, what it hopes to achieve, and why you actually need to put it in place. So the next step then is to really set out what is the information flow. So I always call that the who, where, what, why, when of what you're doing. So making sure that you can answer all those questions and that you can set out exactly what the purpose of the monitoring is and what lawful basis that you're relying on. Then you start moving into identifying, well, what are the risks of this type of monitoring? Like what actual impacts is this going to have on the people that I'm monitoring? And we'd recommend kind of setting those out in tables where you can, showing that whether they're low, medium, high. Then the next step would be to set out how you're going to mitigate all those risks. And I know, as Alex said there, minimization is key. Putting that throughout your DPIA would be really important. And a key thing from an Irish regulator perspective would be setting out, what have you thought about that's less intrusive? And why will that not work to achieve your purpose? I would really recommend that you've got a section in there, other things that we've looked at to achieve the same purpose, and make sure you've detailed those there. Also, of course, like keep a summary of what the outcome of your impact assessment is, and that you're going to keep it under review. So basically a summary report that you can give to a regulator if there's ever a question over what you're doing.
So
very high level.
Very, very useful. I'm going to come to Lionel in 30 seconds, but the reason why we like DPIAs is even if you don't necessarily feel you need one under Article 35, it's something to have in your back pocket if there's ever a complaint, to show that you thought about these kind of things and you weren't just off the cuff making it up. I wonder, Jessica, I don't know enough, but in that H&M case, whether they've done a DPIA, I suspect not. I suspect it was just a practice that had grown over years.
I'm damn sure they didn't. Yeah. And I cannot imagine what they should have written with that outcome.
Yeah, so that is an example, Jessica, where perhaps a DPIA wouldn't have saved them, because what would they have written? We're just interested in very intrusive data sets in relation to our employees. But just coming to Lionel, I know DPIAs are becoming slightly more common in Singapore. I wonder if you give us a minute on that.
Sure. Yeah, so this concept of DPIA was actually introduced in Singapore some time ago, but recently, because of the amendments to the PDPA, they've put in this exception to consent, where you say you have a legitimate interest of collecting data, and you need not go back to the data subjects to ask for express consent. But before you do that, then you have to do the DPIA, and all the aspects which Linda has talked about is the same. You got to do the balancing exercise. There's a prescribed form which our regulators have put forward. You have to do that balancing exercise. What is the prejudice to the individual? Can you do it in any way besides doing the way that you propose? What kind of measures to mitigate against those risks? You put that all in, and then again, same issues. Ensure that you keep a copy of that particular DPIA assessment that you've done. And I think the point is that you have to do an objective one, right? You can't say, well, just go through the motions. I think you actually have to really sit down and pursue it and do a very detailed and as reasonably objective as possible. Because in case there's a challenge, you will have to be relying on the DPIA aspects. And perhaps I think the more salient point will be, in light of COVID situation, a lot of employees are now working from home. A lot of employees are then now using perhaps their mobile phones, their own home laptops, etc. for use for connecting to the workplace. And that's where I think some employers are also installing some sort of surveillance or some sort of monitoring software on personal devices as well. So I think that's very important. And that's where I suppose some gray lines can be drawn, where some potentially some personal data of a non-work related setting may actually be captured by the employers, and all employers have to be very careful about of not crossing the line.
Thanks, Lionel. I'm going to come to Jessica for comment on works councils in 1 second. We just had a question on cybersecurity and privacy are sometimes conflicting. If we want to enforce employers meet security data, we sometimes need to compromise privacy. That's absolutely right. I would say that the stronger your purpose, i.e. we need to enforce our security parameters, the less creepy it is. But equally, there still has to be that consideration of proportionality. If the way you're enforcing security is looking at every single email that anyone ever sends, or you're going too far, then you're obviously going to get in trouble. But the key point there is that if your monitoring is based on something like, we have had 7 incidences of data loss in the last 3 years, we have been recommended by a security consultant, we put in place 1, 2, 3, 4, you're always going to be on far steadier ground there in terms of what monitoring you do. Compare that to H&M. Why they wanted that data, I mean, who knows? It's just much shakier ground. So it's not an absolute carte blanche that you need to do something from a security perspective, because that could be taken far too wide and abused. But it's a much stronger ground that we just like monitoring, because we just want to see what's around all the time. And Jessica, just going on to just a minute on the German sort of focus on works councils, which is something we've hinted at, but I'd like to hear a bit more colour on that.
Thank you, Alex. Yeah, maybe we can widen the scope, because there are several more Central European countries who do have a works council system. France, for example, does have a works council system, and so does the Netherlands. Maybe let me start with how this results for an international corporation who, let's say, they want to roll out, you just mentioned cybersecurity software. Yeah, so let's say they want to protect everything, roll out a software, and since they have one system, everybody's working together in a matrix. They need to implement the same system everywhere, of course, otherwise it won't work. The result is that often there is quite a delay in the implementation process between those countries without a Works Council and Germany or France. So I've seen several cases where we know and we've heard Germany is among the latest countries to where you can go ahead, and so often France is very similar often. So why is this and what is the use? In Germany, by law, a Works Council can be elected by staff in any company with more than 5 staff, but in practice, it is usually more around 100, sometimes even several hundred employees before actually the Works Council is being elected. So once they are in place, they are allowed to so-called co-determination, which means they must be asked for consent before any system which is monitoring can be put in place. And this can, we as a firm are spending a lot of time in those negotiations, conversations, and sometimes also in a special mediation process, which is thought to come to a quick resolution between the employer and the Works Council. And as part of this process, it is quite common to really present the new software, to ask questions. The Works Council is asking questions, critical questions, and the employer is answering. The Works Council may be shown a test login or demand other rights, and sometimes they are closely connected. Sometimes there's also a certain degree of horse trading involved, since the German operation is often under time pressure. So this is really a very important distinction where our perspective and also the French perspective is very different, and the approach is different, and it's important to really put a plan in this time, which will be needed for the process in an international corporation. Thank you, Alex.
Thank you, Jessica. And I think that last point is actually crucial. I have been involved in so many projects where that consideration comes late in the piece and it can scupper the whole project. Because suddenly you've got to add a 6, 7, 8, 9 week or even months.
It can take months, and at least 2 months is certainly still rather optimistic.
Yeah, and just we're just going to go on to some red flags. But before we do that, Annie, we'll just have one more poll, which is a particularly silly poll, but it's just so that I can quickly work out what I'm going to say in relation to Basil's bit. But so are you a bit more worried about monitoring workers now? I will answer that, but there we go. So no one's going to get any great shakes from that. But and as we wait for the results there, we're just going to go on to red flags for 5 minutes, just do it very quickly. I just want to run through a few interesting red flags in the countries we've covered. And then we'll finish off with some horizon scanning, and then I'll cover some questions. So I will do Basil's bit very badly, but I did tell him to talk about this, so I can talk about it in summary. But in France, one of the things that I always notice is how, GDPR and the French domestic legislation, right, we'll deal with that in relation to monitoring, but then how quickly, okay, so that's excellent, we're worrying people. I don't know whether that's good or bad, but hopefully you're also feeling more confident about how to mitigate those worries. But how quickly in France things leap to the criminal. So we're doing a massive case at present in France at the moment that all started, it's very, very boring in some ways, but immediately the French data subjects were going to the criminal prosecutor and asking the criminal prosecutor to get involved. But just before, I'm sure Basil was going to say some amazing things, but actually just this week an IKEA case was reported, and the facts date back more than 10 years, but the French arm of IKEA has in fact been checking criminal records of employees and using spies or false employees to monitor the activity of employees, and in particular union delegates. Now, France has very highly regulated rules on criminal records and so on, but there'll be some GDPR elements here. But the most interesting point is that IKEA and a number of directors are now on trial at the French criminal courts. And, they are allegedly facing multi-million-pound euro fines. And if you read the press, one hopes this won't happen, but allegedly the directors are potentially facing incarceration. Now, that is an unusual thing in the UK. You do get the odd criminal bleed in terms of phone hacking and Computer Misuse Act. And indeed, in the case of Morrison's that some of you may know about, the employee who actually caused those problems for Morrison's did go to prison for a few years for his data theft and so on. But it's in France, it seems to happen with far more regularity than other countries. So you've just got to be aware of that. And I think it's country managers in France, whatever it is, general managers, they'll be all aware. If you're getting pushed in certain jurisdictions, and there might be a criminal risk here, you shouldn't just discard that just because in the country it's not a real risk. These people are all over the press. Guardian and elsewhere. And Nick, I'm just going to come to you for 1 or 2 minutes. Just, are there any red flags in Saudi or UAE that you can mention?
Look, I'm not sure that I'd describe them as red flags, but I think in the UAE, where at the moment there isn't a modern data protection law onshore, so there is this penal risk, then obviously if you obtain the consent of the employee to the proposed monitoring, then that would essentially or effectively eliminate your risk. Now, I wouldn't say that that's a mandatory requirement. There's nowhere in the law that says you must get this, but that's how you would manage the risk. So if it's practical to do so, that's what you would do. The situation in those financial services free zones that I mentioned is different because there's a modern data protection framework that you could work to, and you might find that you have a legitimate purpose for the monitoring, etc. Now, in terms of the position in Saudi, that's interesting. Until October last year, I would have said the same as what I've said for the UAE, which is that obtaining consent will definitely reduce your risk, but not necessarily. It's not specifically required. However, in October, this general interim regulation that came out about data protection, it has introduced a general obligation to obtain consent for any personal data processing, not specifically in a monitoring context. It's not a particularly sophisticated instrument, but it's what we have. So, ultimately be as transparent as you can, obtain consent if it's practical to do so, and in Saudi, because you're required to. But generally, we do recommend trying to adopt this sort of international best practice type approach, because it's not so far in the future that that will be the local expectation, even if it's not a strict expectation or requirement now.
I do always find that very interesting in Saudi and UAE, that there's so many expatriates who work there that they'll be bringing with them their own expectations, won't they, of
Yep.
how they want their data to be treated. I'm sure, Lionel, I'll come to you in a second, but that might be the case in Singapore as well. So many expatriate flows. And David, just in Hong Kong, 1 minute on any red flags or anything interesting that we've missed out?
Yeah, well, like Nick, I wouldn't call this a red flag, but we don't have a specific requirement for a DPIA in Hong Kong, but however, there is guidance notes which require what we call the 3 A's: assessment, alternatives, and accountability. So slightly different format, but obviously assessment being on assessing the risk the employee is trying to monitor to manage, the alternatives in terms of what other the range of options that are available to you to be cost effective, but also practical in application. So, and maybe less privacy intrusive. So to achieve the same objective, and accountability in the sense of the employer having to make sure that it has the right practices in place. We'd always recommend having a separate monitoring policy, in amongst your other HR policies, and that although not strictly required, as I've mentioned, you don't have to get consent. You should try, as Nick already says, well, to get it. I think that's what I'd say.
Thanks, David. I'm going to move on to the last section now, which is horizon scanning, and I'll ask everyone to come back with just their 30 seconds on where they think this might go, and then I've got a few questions which I'll ask. Just from my perspective, what's going to come in the future? Just more and more systems, more and more tech. The tech is really very interesting in all facets. See, as I've already talked about CCTV and facial recognition, but the use of AI and machine learning generally, which obviously we're going to cover in a future Jus Laboris session, but is all pervading in the workplace, and especially in the monitoring sector. We've seen so many innovative uses of technology and AI to track what employees are doing. Now, it sounds like from a German perspective and a Works Council perspective, you're going to have to be as transparent as you possibly can to get that through. But obviously, there is the challenge there that you want to deploy this technology and you don't want to be caught up with employees not wanting to have that technology deployed. Linda mentioned something earlier, location monitoring. We have advised a lot this year on location monitoring because people are working from home. And Linda mentioned some of the reasons, if one of our employees is working actually from Costa Rica and they're a very senior employee, negotiating contracts and so on, is there a tax risk? Is there an immigration risk? So back to the question about security being a foundational purpose for which you can base your monitoring on. Equally, normally I'd say location monitoring and employees, that's a no-no. We don't like that, unless of course you're in a delivery company, you have to track where vans are going and so on. But bearing in mind, if someone is claiming that they're actually in London but they're actually in Turkey, that could result in tax risks for the business. It could result in immigration risks, let alone other data security risks. And so on. It's meant that we have given some advice that we perhaps might not have given a year or two ago about location monitoring, because if there is genuinely a tax risk for a business and they're going to come under the nexus of the corporation tax regime of Singapore or whatever, then you need to know about that. And if that requires some very basic, proportionate and minimal location monitoring, then I think that's probably fine. So just, productivity monitoring is the big one as well. We're seeing a lot of comment on people wanting to monitor productivity, and we'll have to see where that develops, because certainly in Europe and certainly in the UK, thinking back to the start of this session in the Barclays case that I mentioned, I think there are going to be a few battles there about productivity monitoring. It might be slightly different in other jurisdictions. Just keen to have some final thoughts from everyone. I will start with Lionel. Just 30 seconds, final thoughts on future or anything else you want to say.
Yes. Well, in Singapore, I think we are, I don't see many issues coming up from employee monitoring right at the moment, because I think we are quite a high surveillance society as it is, in light of, people prefer safety for, and quite accepting of ubiquitous CCTVs all around. But having said that, I think Singapore is having more multinational companies coming here, many more foreigners. I think there may be a pushback if for example, the monitoring is not proportionate and not reasonable. Then we're probably likely to see some pushbacks and some further tightening, and so maybe some case law as well that will come about and moderate some of these surveillance for employee monitoring. Yeah.
Exactly. So we might see that furore over the COVID app just develop into potential angst over workplace monitoring. Jessica, just 30 seconds.
Thank you, Alex. Two things. Maybe one more risk to add to our list of concerns. Recently, we've seen more cases of damages being claimed from single employees. So this is becoming a bit of a trend. The amounts are certainly not in any way comparable to those which are being awarded by courts or data protection authorities. Nevertheless, I want to give a different thought, and this is in the non-legal literature. You read a lot about control only bringing you so far with employees' productivity. You just mentioned it, Alex. And so there's also a school of thinking that leadership should be different and should be more about trust and involvement and enabling people. I know it's not always getting you where you want, but I think it's also a thought worth thinking.
Yeah, thanks very much, Jessica. And Nick?
Was bound to happen, sorry. I think the key thing, and it's not specific to monitoring, but to the extent that a lot of countries in the region, whether it's Saudi, whether it's Egypt, Bahrain, and so on, they are introducing, their versions of modern data protection laws. They're not necessarily being drafted to an international standard or with international concepts in mind. And it's, I would say, inadvertently creating a potential minefield. Things like criminal liability for data protection officers that, fail to get a permit from the regulator. Like some of it, it's just, if anyone wants a job as a data protection officer in Egypt, let me know. But, the sort of risk type, it's just not going to be practical. So yeah, it's going to be a minefield.
That's very interesting, Nick. And David?
I just thought it's interesting that from a legislative perspective, this sort of thing, as you say, with emerging technologies, as with all law is always very slow in catching up. I mean, in Hong Kong, we have these proposed reforms that were introduced in January last year. That was at the almost practically pre-COVID, of course. But since then, they have they haven't really indicated any sort of law changes on this, even though they have issued guidance notes on working from home arrangements for not just organizations but employees, and part of these talk about security measures that must be placed for data management. So again, that which includes stopping data leakage and data monitoring. So I mean, it'd be interesting to see, I think, whether any form of they'll catch up on that or insert something on legislation. So.
Great, thanks, David. That's very interesting. And Linda, just to come to you, and then I've got one question that's coming. That's really $1 million question. I might ask. I'll have to pick on someone. Sorry, as it's a live question. But Linda, just your final thought.
Yeah, I mean, my thoughts are probably more on trends we expect to see. Like, we're seeing a lot of requirements coming from customers to our clients to put in certain data loss prevention software, which can be quite intrusive. So it will be access to cameras, access to audio. And just for our clients trying to get those across the line where they're a requirement of their customer contract can be quite tricky, and that has to be really built into the negotiation process. I also expect we'll see a move back from BYOD, which I think Lionel touched on earlier, that's actually so much harder to get your security and monitoring software on. So I think we'll see a shift back from that. We're also seeing a trend towards biometrics, and I would put a big health warning on this in Ireland. Our regulator really doesn't like biometrics. We recently had a case where they stopped biometrics being used for prison guards accessing a prison. So if you haven't got a legitimate reason for security there in a prison to use biometrics, I don't know how you would get it in place in the workplace without very, very specific reasons. So those would probably be my trends.
Thanks. That point around clients demanding things is something that will come up in the criminal records check session that we do later in the year. It is often, depending on your type of industry, that if your clients are mandating you do certain things to your employees, it's all very well to miss that in clause 3 million in a contract, but you've actually agreed something that is not possible in Germany, is not possible in Hong Kong or whatever. So you do have to watch that. And the big one obviously is criminal records check, slightly off topic, but you must criminal records check all your employees. Fine that the contract says that, doesn't mean you can do it in Germany or France, potentially, but we'll talk about that later. So we have had a very interesting question. It's a sort of $1 million question. So in France, I understand it's unlawful for an employer to open an employee email on the employer's work email system where it's marked private and confidential. I think it's slightly more nuanced than that, but yes, transparent. If someone's marked something as private and confidential, personal, it obviously raises the bar for any intrusion on that. But is that unique to France, or does it apply in other countries too? I mean, I'll say it's the $1 million question everywhere because it raises that bar. I just might come to Jessica and Lionel. Let's say, Jessica, what about Germany? If someone has just written, and it's not BYOD, it's not bring your own email system, it's using Microsoft Outlook, but they've written strictly personal in that email. Is that a bar to a German employer looking at that email?
Certainly, yes, of course, fully agree. I recall one German case where they made a distinction between the word private and personal, which was a bit lawyer-like thinking, but nevertheless, I think you can be fairly sure if the employee expresses the wish to keep their secrecy, their privacy, you should have very good reasons to go beyond that.
Okay, that's interesting. I'll come to you, Lionel, in a second. I mean, because the position in the UK is slightly different. We encourage people in our policies to make clear you shall have no expectation of privacy. We always write this in policies. Even if you mark something as personal and private and confidential, we will try not to look at it, but we may do, because we have seen people writing private and confidential and then combining, attaching all the business secrets and so on. So Lionel, just 15 seconds on Singapore. Is that it? Would that change the position? Would that give more protection, or is it irrelevant?
Just the fact of putting that label, I think, it's not a cure-all. I think it will be quite similar to the UK position. If there's no expectation of privacy, especially if you're using a work computer, the employer will be able to access that computer, even if you put the words private and confidential. Yeah. Sure.
And we do see interesting things where I use my work account to check bank accounts or check health status and things. So there might be things where we would advise an employer, if you see it and it is private and confidential, just remove it. Don't look at it at all. But it's not sounds like there's an prime example of how the law is going to be different all around the world. And there's been another question about regulators becoming more lenient towards monitoring in light of the pandemic. Not really. You've seen H&M, that's the opposite of lenient. However, the questioner talks about there about obligatory measuring temperature by employers. Now, yes, we've seen things that are unbelievable that never would have happened a year and a half ago, having your temperature tested when you come into the workplace. But even there, I'm afraid it's country by country. In France, it's more frowned upon than in Germany. In the UK, it's less frowned upon than in Germany. Singapore is much more open about those kind of things. So I'm afraid it is a mishmash of different approaches in different countries. I'm very conscious it's 10 o'clock. I just want to say thank you to all the speakers. Really, thank you very much indeed. It's been very interesting. And I'm very sorry to everyone for being a low-rent French speaker. But Basil is obviously in court now, no doubt winning, I hope. And I will hopefully see everyone with some of these speakers later in the year and new speakers in the next session, but I think it's in a few months. And I will pass over to Annie to wrap up. And thank you to everyone.
Thank you.
Thank you, Alex. So for more information about today's topics, you can visit our data privacy page of our website. And I have included the link just there. And you can find several very interesting resources and articles there. Then for more information on the webinars that we do and also podcast, you can visit these two links and find all recordings of the past sessions. So we'll have more sessions also on data privacy throughout the year, so you can go there and secure your spot. So also from my side, I would like to thank everyone for attending, and thanks also to our panelists for their insights. So with that, the webinar will now be ending. Thank you.